those of you who are longtime listeners to this program or readers of my book, Unequal Protection, How Corporations Became People and How We Can Fight Back, will recall that I have repeatedly, over and over and over and over again, tried to educate people about Article 3, Section 2 of the Constitution. Larry Kramer, who was the former dean of the Stanford Law School, wrote a great book called The People Themselves about this topic and, about judicial supremacy and judicial review. The idea that the Supreme Court is the ultimate sayer of all things in the United States. The Supreme Court has final power over everything. That's what most people believe. In fact, it's frankly what most legislators believe. It's not what the Constitution says, not what the founders intended or believed. And certainly I refer you to the Federalist Papers on that in the 70s and 80s, as I recall. Federalist numbers, in the 70s and 80s, they were all from 1787 to 1789, and particularly Hamilton's stuff. But what the Constitution says is that Congress can control the Supreme Court. And it doesn't just mean the number of people on the court, because Congress has changed the number of people on the court a number of times since the Washington administration. And it doesn't just mean that Congress can say you're going to be in this building or that building, because Congress has done that too. But literally, Congress can regulate pretty much every aspect of the Supreme Court's functions. And here's what it says. This is Article 3, Section 2 of the U.S. Constitution. First of all, in Section 1, it goes through all the areas where the Supreme Court has what's called primary authority, or primary. What's the word I'm looking for here, Shano? Power, judicial power. Yeah, here it is. Section 2, the judicial power shall extend to all cases in law and equity, original jurisdiction. Thank you, Shano. Arising under this Constitution, the laws of the United States, treaties made, it'll affect ambassadors, admiralty law, maritime law, controversies to which the United States is a party, controversies between two or more states, all this kind of, these were all cases that the Supreme Court could just take the case and rule on it, and their rule is law, right? And then they get to the second part. In all other cases, in other words, if it doesn't have to do with admiralty law, or it doesn't have to do with a whizzing war between Texas and Oklahoma, or if it doesn't have to do with something like that, an ambassador, the stuff that was listed before. In all other cases, which is 99% of what the Supreme Court does, before mentioned, in all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction. In other words, they're the final appeals court. The buck has to stop somewhere, right? Shall have appellate jurisdiction, both as to law and to fact, with such exceptions and under such regulations as the Congress shall make. Not might make or may make, but shall make. So it was clearly the intention of the founders and the framers of the Constitution, that Congress would regulate the Supreme Court. Now, I have argued for years and years and years that Congress should get their damn act together and pass a law saying the Supreme Court may no longer refer to its own decisions, which were never legislatively backed up. Its own decisions in Santa Clara County versus Southern Pacific Railroad, 1886, Buckley versus Vallejo, 1976, Citizens United, 2010, and McCutcheon, 2013. That in those cases where the Supreme Court handed personhood rights, power, off to non-persons, corporations, and in 76 in Buckley, and then reaffirmed in Citizens United in 2010, and in those cases where the Supreme Court also said giving money to politicians, political action committees, influencing legislation, all that kind of stuff, we used to call that bribery. It used to be against the law, but ever since 1976, it's been a protected constitutional behavior, protected by the First Amendment. And I have been saying, I've been arguing for this, I've been calling for this, and like I said, I wrote a damn book about it, saying, Congress, you have the legal right and ability. In fact, I had Phyllis Schlafly on this program at least a half a dozen times to tell you she agrees with me. She's passed on now, but my point is that this is not a left or right issue. And is that Congress should write a law saying, Supreme Court, you may not refer to these decisions anymore, and we are overturning them. End of discussion. And people say to me, oh, it'll never happen. Come on, give me a joke. You got to give me a break. You got to be joking. Congress isn't going to do that. There's a word for it, by the way. It's called court stripping. It means stripping the power of the court within the legislation itself. Well, let me read to you the text of a bill. It does not have a number assigned to it yet, so it's still in committee. Oh, H.R. 177. It does have a number assigned to it. Okay, H.R. 177 in the House of Representatives. This is presented by Congressman Steve King of Iowa, Republican. Used to be a regular guest on this program. I think I irritated him once too often, but, you know, what the heck. And what he's trying to do, you know, the Supreme Court has ruled in favor of Obamacare 4 or 5 times, various parts of Obamacare. But they've ruled in favor of it. So what he's trying to do is strip those. He's trying to court strip this. So here is the, it's a 2-page bill. A bill to bar Supreme Court decisions in certain patient protection and affordable care cases from citation. In other words, the court can no longer even cite itself in its rulings. We are overturning you, Supreme Court. This is Steve King's proposed law. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled under Article 3, Section 2, which allows Congress to provide exemptions, exceptions, and regulations for Supreme Court consideration of cases and controversies, the following cases are barred from citation for the purpose of precedents in all future cases after enactment. The National Federation of Independent Business versus Sebelius, King versus Burwell, and Burwell versus Hobby Lobby. It's a 2-page law. That's the law. You, Supreme Court, we, Congress, are going to assert our Article 3, Section 2 power and tell you, Supreme Court, you can't stop, you can no longer defend Obamacare. Now, obviously, you know, I disagree with Steve King on the essence of it. You know, I would like to see Obamacare improved dramatically. I'd love to see a public option. I'd like to see us move towards single payer, all that kind of stuff. But forget the politics of it for a moment. Here you have a Republican United States member of the House of Representatives who's no idiot. I mean, he's kind of out there, but he's no idiot. Steve King has been around the block for a long time, and he's much beloved in his state of Iowa, saying, here's a piece of legislation that specifically prevents the Supreme Court from supporting Obamacare in the future. We could just as easily pass legislation that says that the Supreme Court may no longer say that money in politics is not bribery, it's First Amendment free speech. Sorry, Supreme Court, we're going to throw that doctrine out. And that corporations are people. Sorry, Supreme Court, we're going to throw that doctrine out. And you may not cite those cases any longer. Brilliant, huh?
You're listening to the Thom Hartmann Program. Call 202-808-9925.
I wonder if Steve King has been listening to this show or if he and I have had this conversation before, because I talk about it so often. But it's fascinating. It's happening. I mean, it's not going to happen, but it's like